Diana, what we'll do though is we'll break when it's like a natural break.
Okay, it's on.
Oh, okay, so it's not exactly at 12:53, I stopped talking and say ethics 101
No,
VLP.
it'll break. So we'll.
Jim will be up there then by the time I'm done.
Great.
Okay.
Thank you, Greg.
Thank you. Okay, I think we're back. Before we do anything else, Jim would like to make a comment on this.
Well, my comment, and by the way, kudos to Diana to have put together this handout. But I think the State Bar who wrote these opinions is not being totally honest and is almost pretending that 4503 is not there, because it is an absolute dilemma. 4503 would seem to dictate that you don't disclose. Rule 3.3 would seem to dictate that you do disclose and correct the falsehood. Diana.
Okay. Are there any other questions? I think that while we were on break, somebody had.
Could you direct us to where 4503 is in our materials? I know you said it before, but
It's under.
post-break.
It's under.
Middle of page 9.
It's kind of buried in opinion 741, since that's where I found it.
Here, I found it.
And you probably want to read and reread that section very carefully, because Jim and I have spent a lot of time just talking about this section and what does it mean, because again, it's an evidentiary section. So it means that we cannot disclose our client a confidential communication from our client as a witness or present evidence. But if we go back, let's say hypothetically, we have a case where a client comes to us and says, I just lied on the witness stand. I wasn't dropped while I was being transferred. I thought I was going to be, but I wasn't. And that was a critical issue at that trial. And you go back and you correct it. Haven't you filtered, played around with the evidence? So even though you might not be able to testify to that communication that your client, I lied, it's gonna alter the evidence, and it's an evidentiary protection. So I think it's a problem. I mean, I think that they have not really thought through. Personally, I think 3.3 is a problem because it conflicts to some degree with 4503.
And by the way, 4503 does apply to administrative hearings.
It doesn't.
Well, yeah.
It does.
It does.
If you look at the definitions in the CPLR, they govern administrative proceedings.
But 4503 is in the evidence section, which makes me think I haven't done any research, but that they were thinking about like a husband and wife privilege. You can't compel a wife to testify against her husband, for example. So I thought 4503 is more like you can't compel the attorney to tell what the client said about other stuff. Just that the purposes are different versus.
It is, but again, when your client says, I lied during the trial, and you have to take remedial action, what are you doing? I mean, you may not be testifying, but it's also the presentation of evidence. And so you're going to alter the evidence that's now before that tribunal. So I think you're right. And I think, courts may be very inclined if they ever have to look at these two issues. Say that somebody gets reprimanded for violating 3.3, and they come in and they say, yeah, but look at 4503. How can you force me? I haven't found anything. Ethics opinions are saying, that's not our issue. That's a legal issue, and we're here to talk about ethics. I think it's going to take a court to actually, something's going to have to get before a court to say whether 4503 trumps, and will they limit 4503 because they find the attorney's conduct egregious and against policy. Now, the whole basis to again, when you talk about ethics changing, under the old code, they really thought it was important to protect the attorney and client relationship. And they wanted people to be able to come to their attorney and tell them everything and not have to worry about that confidential communication being violated. And I suspect, since 4503 has been in existence far longer than the rules, that policy, is what governed 4503. Because 4503 really sounds very far-reaching when I read it. And then they decided, 2009, I mean, who knows why it took them so long to develop a version of the code, of the rules, and to abandon the code. But they went the way that the Bar Association did. The ABA, I think, has a very similar provision, and have decided that now it's public policy that we can't commit a fraud on a tribunal. And that's more important than maintaining our attorney-client relationship. Eileen?
Just getting into a much more theoretical, if we have the luxury to think beyond all these difficult rules, I'm wondering if this is an after effect of terrorism in September 11th, and that even though it didn't happen immediately, that part of what's changing in the world is the fear that terrorist acts can occur. And there have been some things in the New York City area. There was a female civil rights attorney who was representing someone accused of terrorist activity. I don't know, and it's for another date, but it would be an interesting issue for a professor type to explore.
Yeah, what happened culturally that we decided to forego the protection of the attorney-client relationship and to protect the integrity of the adversary system instead? I don't know. And you're right, it could have been something like that. I mean, we really have become a little bit more snitch on everybody kind of mentality. But 837, I really, opinion 837, which is in your materials.
Top of page 10.
Okay, thank you. I think what's important there is that the remedial action may not have to be, oh, my client lied. And on there they were saying, is there something other than that might work? I mean, could we just withdraw the evidence? And the opinion was yes. If that corrects, if you're able to, and you can simply say, I'd like to pull that out of evidence without having to confess that your client confessed, then that's perfectly appropriate because you've now corrected the record. So taking remedial action may be less involved than just saying, oh, my client lied, my client committed perjury. But you have to protect the client, even though you can only take what's reasonably necessary to get the job done. So that kind of gives you an out. And then there's another opinion. I should have to wrap up in a few minutes. Ethics opinion 2013 issued by the New York City Bar Association, which reinforces that the duty to correct, to take reasonable remedial measures, lasts as long as reasonable remedial measures can be taken. So if there is a period of time where you can either ask the court or the tribunal to correct the decision or appeal to another tribunal, then that's the time period. You don't have to snitch on your client if it's not going to have any effect. And all you're going to do is make your client look like a liar or somebody incorrect. There's just a couple cases I want to quickly mention because I think that they're from out of state, but again, they were decided under the rules, so it could happen here. In Chase, Ingersoll, there was a poor person motion. So a number of us do poor person motions, and in that case, they left blank where they asked about real estate. And the client had real estate. Now, admittedly, there was less equity in the real estate than debt, but they believed that the attorney knew about the real estate and had allowed the client to keep it off the affidavit, and they sanctioned the attorney for letting that vacant space convey to the court that there was no real estate when the attorney probably knew there was. And then the next one is really important because the client was kind of in la-la land during the hearing or trial, and the witness lied. And the attorney claimed he never heard the testimony, and it didn't save him. So, it's really an important trial concept. Don't zone out when your client is testifying, because if your client perjures himself or herself, and you knew that had you been paying attention, so a nice trial technique. Pay attention. Jim?
Yep. Okay, I just want to go through, a lot of this we'll leave to your reading, but I just want to go through a few key principles that come out of other rules, and I'm at the bottom of page 12 here. Lawyer has an obligation of fairness to the opposing party and counsel. Rule 3.4, lawyer shall not, A1, suppress any evidence that the lawyer or the client has a legal obligation to reveal or produce. And at least in the areas where I've practiced on an administrative level, Social Security, Medicaid, public benefits, unemployment, I'm not aware of any place where I have some obligation to reveal something. And even in federal and state practice, I don't recall any place. But Diana, you have a very specific example from family law practice.
Well, yes, in family law, you have an obligation to produce your client's financial affidavit. And so I think you go back to that situation with the poor person where you left a blank when you knew your client had property and they didn't put it on their financial affidavit. So I think it's important that we make sure that we believe, we have no reason, we don't know that the evidence is false on the affidavit.
And I guess having said that, and having given the example of the informa pauperis petition, poor person's petition, I've done many of those. And don't ever play fast and loose with that kind of stuff. The facts are going to be what they are. And if your client does not meet the standards, they don't meet the standards. Don't hold back. Number 4 here, and again, I'm just going to hit a few. Knowingly use perjured testimony or false evidence. And at the top it says shall not. There's no may here. Lawyer shall not. And we're going to talk about this notion of learning after the fact, because it's going to come up in the hypothetical. Is it too late to correct? Lawyer shall not, top of page 13.5, participate in the creation or preservation of evidence when the lawyer knows or it is obvious that the evidence is false. Again, I'll leave this to your reading. We're going to give you some context in the hypothetical. I'm going to skip through the rest of page 13. Top of page 14, under E there at the top, Rule 8.4 defines professional misconduct as, among other things, that second one. Engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. And by no means would I suggest, because we represent poor people, that they're any more likely to lie than anybody else. I once had a college professor in a clinical program tell me people lie. But if we discover the lying or the false representations, we can't just stand idly by. Now, Roman numeral 5 here on page 14, 5152 talks about the obligations of attorneys and people working in a law firm as subordinate attorneys working under attorney supervision. B1, a subordinate lawyer does not violate the rules if that lawyer, quote, acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. So if somebody like Ellen comes up to me and we've got a tough case where we don't know the real answer and I come up with the answer, it sounds like Ellen's protected, but I'm not. But,
Sounds good, Alan.
Good
yeah,
to
it
know.
sounds good to Ellen,
Not to Jim.
not to me. But here's what's really important. Rule 5.3 pertains to non-lawyers, not my term, paralegals and advocates, and we believe also applies to anybody else in the office who's going to handle information, secretaries, law students, any other kind of volunteers. The law firm must adequately supervise non-lawyers. Lawyer will be responsible for the conduct that would be a violation of the rules of professional conduct. But the important thing is anything that we talk about today, including the discussion in the hypothetical, which is based on an administrative hearing, these rules are going to apply to the paralegals and advocates that may be involved in that representation. So, any questions before we get to the hypothetical? Eileen.
I'm looking on page 14 at F in the middle of the page. It says Rule 8.3 requires lawyers to report a known violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthy, or fitness as a lawyer. In its literal terms, it might mean that if I and 5 other lawyers have a case against lawyer Joe Schmo, and Joe Schmo turns in an obviously false financial affidavit, are all 5 of us subject to discipline? And if we don't go to the bar and tell on Joe Schmo, you could take it to many other situations. But what's scary is that not only can you get in trouble, according to this, for something you or other people in your office might do, but that as a lawyer, you are a deputized policeman to police other lawyers.
Yeah, snitch on each other.
Have there been prosecutions under this? And how broad is the swath? I mean, for example, don't do it very much, but in my earlier years, many lawyers showed up drunk. Or at least several lawyers showed up drunk. And everybody knew they were drunk. Am I, as one of the people who happen to smell the alcohol on their breath, do I have a duty? And how many other people in the room have a duty? If there was a lawyer sitting at this seminar smelling of alcohol, would we all have a duty?
Well, I'm going to answer the easy part. At least under the Code of Ethics, I don't think we have a duty to disclose the fact that somebody here smells of alcohol. But I'm going to let Diana answer the more difficult question
Oh,
if
thanks.
you discover it in court.
Yeah, I don't have a clear answer to that. I mean, I think, say that your client has, or your opponent has produced a faulty affidavit you think is bogus. But you, despite what you've heard, we're entitled to believe our clients, and he's entitled to believe his client unless he knows. And so I don't think I'm going to assume that he knows his client is lying in that financial affidavit. I'm going to assume he doesn't know that his client is lying. And I'm not going to assume that somebody is incompetent because they smell of alcohol. Probably. So I looked at this probably a year ago, but to be honest with you, I don't remember. I don't think there's been a lot of ethics opinions on it. It's hard to know what's happened to people because I think all those things are confidential. So how many people have been pulled in? Oh, you should have known your opponent was drunk. Sanctioned. I just...
And he doesn't have to just be drunk, he has to commit a known violation of the rules. So, if he's functioning okay,
Yeah.
I mean, you have to know that they also committed a violation.
Right.
And you'd have to know the rules to know that they committed a violation.
Right, and I think, haven't, again, looked at thoroughly, but not just reasonably believe maybe he did,
Right.
but you'd have to know somehow.
Yeah, I guess I would suggest
A substantial question. It has to
tread
raise a substantial question.
lightly in terms of taking this too literally and starting to blow people in unless it's very, very clear that somebody is involved in absolutely dishonest conduct. But it's one of those tough provisions, and we don't have crystal clear answers. Let me pause very quickly for the people that are viewing this after the fact as the recorded archive session. Our next code is Ethics 101 VLP. That's Ethics 101 VLP. So, let me move on. You've got this two-page hypothetical among your materials. And what we're going to do here is I'm going to read to you the introduction in Part A. Diana will do Part B. We're going to go back and forth. But we're hoping that you guys will now get involved much more in the discussion as we go through this hypothetical case. And the scenario that we're going to give you is based on a Medicaid hearing, and it's based on a practice that Diana and I are very familiar with. And we've used a similar hypothetical for a training we did for a national audience. But what I will say is, even though this may be outside the practice of a lot of folks, these issues can occur in any of the other contexts, the various administrative hearings, the Social Security, the unemployment, the family court, and so forth. So, and I'm just going to kind of remind you that as we're going through this, we're going to be dealing with this dilemma of the Rule 1.6 confidentiality of client information protection versus the Rule 3.3 requirement of candor toward the tribunal. So, we've got Sam Jones, age 26, who suffered a spinal cord injury several years ago, and as a result, he cannot walk or stand and needs a power wheelchair to meet all his mobility needs. Sam's current wheelchair is consistently broken, and he needs a replacement wheelchair. Sam is seeking Medicaid funding for something known as a standing power wheelchair. Medicaid denied his prior approval request for the standing wheelchair, claiming, first, that he does not need a standing program to prevent bone density loss. Sam's most recent bone scan, showed no indication of bone density loss. And even if he did need a standing program, the cost of a standard power wheelchair and a separate standing frame combined could meet his mobility and standing needs at a far less cost than the more expensive standing wheelchair. Sam has asked you to represent him at an administrative hearing. And I just want to note here, just to provide you a little bit of context for this if you've never practiced in this area. Under Medicaid policy for approving durable medical equipment, or DME, Medicaid will only approve funding for an item if it is the least costly, equally effective alternative that will meet the identified medical need, i.e. the cheaper alternative is always okay if it will accomplish the needed medical benefit. And as we get into this hypothetical, you're going to see that two things have to be established, at least as relevant to this hypothetical. One, that some type of a standing program for a person who sits in a wheelchair all day is a medical benefit and is medically necessary, something that can be addressed through the Medicaid program. And then number two, assuming the answer to number one is answered in his favor, is the standing wheelchair the least costly, medically effective alternative to accomplish this? So, Part A, in the course of preparing for the hearing, you interview Sam's physical therapist, who submitted the original letter in support of Sam's request for prior approval. This therapist has been working with Sam at least once per week for the past 12 months. While the letter outlines the medical benefits Sam will derive from standing, the letter fails to adequately explain why the less costly separate stander in combination with the standard power wheelchair would not work for Sam. You discuss this with the therapist, who tells you that a separate stander might work for Sam, but that Sam wanted the standing wheelchair so badly that she decided to go along with the request. What is your obligation regarding the disclosure of the therapist's comments to you? And since you've been attentively listening to us, I'm sure you all know the answers. So what do you think your obligation is, having had this discussion with the therapist, do you need to disclose this at the hearing or to whoever decided the prior approval request?
I'd hang on the words might.
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 Might. Well, let's bring up the rule. Rule point 3.3. Shall knowingly make a false statement. This is what it addresses. So if the word might is in there, and she has submitted a letter that says needs the power wheelchair to benefit from the power standing wheelchair to benefit from the standing program, the fact that she letter says might be able to accomplish the same thing with the separate standard, John, you think that's enough to take it outside the scope of the role?
I think it can be because we don't know that her assertion that he needs it is false. We know that her assertion might be false. So actually, which kind of leads us to believe that we think her assertion is false, but from what she said, she didn't take us into knows that it's false.
Anybody think differently?
No,
Linda.
I don't think differently, but her letter doesn't say that he can't use the separate.
Yes.
It sounds like it's more a letter about the benefits of standing, and she doesn't get into how he stands, what he needs to use it.
Diana, who more recently is involved with these cases on a day-to-day basis, what would you do in a case like this, Diana?
Well, I would decide whether or not I wanted to even use her as a witness, because, will I have a problem then? What's she going to say at trial, at the hearing? Or I may want to explore this option with her more thoroughly as a case strategy and say, well, has he ever been dropped while he was transferred? And maybe she hasn't read the articles that talk about the additional benefits that a standing wheelchair would confer that a separate stander would not, because by virtue of the fact that you're in it, you can get up and down all day long. You can't do that in a separate stander. So I think I just think it's, I would probably want to explore it more with the physical therapist before I used her for trial.
Just an observation based on the literal language of the rule. I believe John is right. The word may, might, I think takes it outside the knowingly. Once you engage in further discussion with your witness, might be, yes, you cannot, once she starts to say things that move it into the false statement, you can't just say, well, I'm not sure I heard that last thing you said. Hold your hands over your ears. So be careful. Diana, we'll let you go to part B.
In preparing for Sam's hearing, you obtained an additional PT report written 18 months ago by Sam's former PT commenting on Sam's suitability for a standing wheelchair. This report documents the medical benefits of a standing program, e.g. to maintain bone density, improve bowel and bladder function, reduce incidence of pressure sores, etc. The report then goes on to state that Sam can achieve these benefits through a standing frame and suggests not pursuing the standing wheelchair. No further explanation is given concerning Sam's need for a standing wheelchair, and no request was submitted to Medicaid for a standing wheelchair at this time. What is your obligation regarding this additional report? Are you required to submit it at the hearing? Oh, I see a hand going up.
I would guess no, because it's an opinion, it's not a fact. And I know in personal injury, you go to Dr. 1 who says your back is fine, and so you go to Dr. 2 and he says, no, you have long-range injuries, and you're going to go with Dr. 2.
Mm-hmm.
So,
Yeah, I agree. I think that an opinion is not, in fact, that's what I've done, not fact or law. It states clearly. You can't make a false statement of fact or law, but it doesn't say anything about opinions. And medical stuff is always straight opinion. So, and opinions can vary. Now,
But let me change the facts, Diana.
oh, and I was going to change the facts, but go ahead.
What if the earlier report was by the same physical therapist? Would that change your thinking?
No, I would probably assume, and without exploring, that he became more knowledgeable. He acquired additional information that would lead him to a different, or her, to a different opinion. So, I mean, technology is changing. The physical therapy is changing as more people use the standing wheelchair and people are getting it. Therapists are starting to consider things that might not have been considered a year ago, 5 years ago, 10 years ago. And Jim's right. Once you start exploring that with the physical therapist and you find out whether those facts, whether you can continue to believe that, you might be pinning yourself into a corner. I would just assume that she changed her mind. But what if you're asked, you're at the middle of the hearing, and you haven't produced that because you have no, I agree, I think there's no obligation to produce it. What if you're asked by the ALJ whether there have been any other reports produced on this issue? Then what do you do? Bear in mind that I'm not aware under Medicaid law that you're required to submit evidence that you don't have to submit that bad opinion report. But what if you're asked? I mean, how do you handle it?
You don't really have an opponent there, so maybe it's not relevant to that tribunal, but I'm looking on page 2, near the bottom, with the Model Code of Professional Responsibility, and it says concealingly or knowingly failing to disclose that which is required by law to be disclosed. Now, I don't know, and this may take it too far, but suppose there was another side, and that side subpoenaed or sent you a discovery demand for all reports and documents in your possession pertaining to the suitability of a type of wheelchair. Then you're required by law to disclose stuff which has been subpoenaed or with which there's been a discovery demand unless you've moved for a protective order. So I may be mixing apples and oranges, but I'm interested in how that figures in.
No,
Linda?
I'm not sure that's the law, because I thought you only have to give out expert reports that you're gonna rely upon. So I don't know if they have the right to discover other expert opinions that you might have gotten.
Yeah.
So
I'm just going to suggest that a default, and it's not always going to work, is if you're an attorney representing a private individual, that anything that you've gathered is your attorney work product, and it's not subject to disclosure through any kind of discovery requirements. But that may vary from proceeding to proceeding. I'm not aware that you ever are required to essentially empty the contents of your file.
Now, I know this doesn't, this was a number of years ago, and it was under the code, but I worked for a personal injury firm too and his opinion was, well, even if I don't produce this, what's the recourse? And they find out about it later. Well, then they ask to preclude it. Well, that's what we want. So the penalty for not producing it under, the disclosure rules is that they can preclude you from using that as evidence, which you don't want to use as evidence. So,
But all of this begs the question of how do you answer the ALJ's question?
I think I would say nothing that we're going to rely on here.
yeah.
And then, let them insist that I honestly don't think they would be entitled to reports that you've chosen, especially because now you don't have that second expert there to say, well, when I said this, it was because of this, and now it's different because of that. I mean, all that, Sam is bigger now, all those kinds of things. So
Yes.
I think it's different with expert opinions. Now, if it was facts, x-rays or something, I think a fact would be different.
Yeah.
Let me just say that the fact here, or potential fact, would be that her belief is something other than what she put in the letter. Does she really believe what she said? If she told you that it was an outright lie, and that it was just a weak moment, and that's not her opinion, See, we're the presenters, we can change the facts any way we want.
Yeah.
You
And
make
we
it
will.
harder and harder when you change the
Why would you even want to use her as your witness then?
Why would you want to use her as a witness? But if she said that to you, would you have any obligation regarding the report that was already in evidence?
Yeah.
Or what if her service coordinator already put that report into?
You can't
a
use it
Medicaid,
if it's
and
wrong.
it's already in the record.
I have and for different reasons, but there have been a few instances where I've suggested somebody start over. Maybe go to a wheelchair clinic and get evaluated, get a new letter, start a new prior approval. Because I can't prove my case.
Because
With
then you
that
get
letter,
a new opinion.
Yeah, I get a new opinion.
I'm-
Maybe from a new person.
I'm going to say under the most recently altered set of facts, where she says to you, that's not my opinion, you have an obligation to take remedial measures unless you're entitled to rely on CPLR 4503, which at
It
least...
wouldn't be a client confidence, though. I mean,
No, I
it's,
don't.
You're right, thank you.
Coming from
it's
the
not
client.
the attorney, it's not your client telling you something in confidence. That's the privilege.
Yeah, okay.
But what would you do if your client said to you, I met with my physical therapist and I told her that I had to have this wheelchair and she had to write that in the report, regardless of whether it's true or not? So I'm messing with your facts a little. What's your obligation there? When your client tells you that he knows.
Yeah, well, sometimes my clients know more about their medical need than, and it's really incumbent on them, I think, to discuss that with their physical therapists and their doctors. So, this person, he sits in a wheelchair all day long, and he knows that is getting stiff. He knows that his joints are starting to freeze. He knows all that better than anybody knows that. So I don't automatically assume that just because the request is client-driven, that it's wrong.
Okay.
Gail, I'm going to suggest, and then maybe we can go on to part C. I'm going to suggest a way to analyze the statement that you just gave us, that the client told the physical therapist, you have to do this. So the question is, looking at Rule 3.3, what is the false statement? Because we're looking at the physical therapist statement.
Not the client.
Have we got any evidence that it's false?
No, you don't.
It may have been her opinion already, and she was going to write that, he was going to write that, notwithstanding whatever the patient said. So, always go back to 3.3. Is there a false statement? I don't think there is in that scenario.
Okay, I'm going to switch this over to Jim.
Okay, part C. During the hearing, Sam's doctor testifies by telephone, which is fairly common. In his testimony, Dr. Bones states that there are many studies that indicate that the use of a standing frame alone will prevent loss of bone density and prevent the incidence of decubitus ulcers, pressure sores, for an adult like Sam. After the hearing, he researched the issue, found the studies Dr. Bones referenced, and also found a study that specifically found no conclusive evidence that standing therapy will prevent the loss of bone density. And just keep in mind, so that this makes sense, at this particular point, we're only trying to prove that standing is beneficial. Later in the hearing, we're going to prove that the standing wheelchair is the best way to accomplish it. But based on this testimony, do you have an obligation to let the hearing officer or the ALJ know of your research? Somebody's saying no. Why not?
Because you're retaining an expert, and it's his job to do the medical research. It's your job to do the lawyer stuff. I don't think you have to go behind your expert's back and find, and it's a bottomless pit of research out there. You happen to find one that says something else.
And Linda, doesn't that help your case then when you're preparing your witness, because then you know the contrary opinions and you can have your witness then discredit whatever other reports are out there? I mean,
If you were getting ready for an adversarial, I mean,
Correct.
Medicaid hearings,
Right.
usually they're not.
And our
Well, they might, but.
our
Right.
facts are assuming you did this research after he testified.
Right.
After the hearing. but I would agree with Linda's assertion. Diana?
Even if you did the research before he testified, I mean, I'm making a confession here on the record, but Jim and I did an amicus brief for, which circuit was it? Fifth. And our brief dealt with the medical benefits of standing. And I read, I don't know how many studies I read, and, you know, a lot of them were kind of like medical gobbledygook. And I picked the ones that, to me, were the clearest as to the medical benefit. And there are a lot of, it's impossible, and even people who've written, medical experts who've written position papers, they have to look at each of the studies and decide which ones are more probative, which ones have, you know, better science to them, etc. So,
they're bringing all their experience with actual patients.
Right.
so even if
when
I
they
knew
do
this
those
before, I don't feel that obligated to tell people that there's
I
there's
think
other
it's like
studies
Gail
out
says,
there.
It's good advocacy prep,
Yeah.
to know about the opposite.
Yeah.
Right.
So the second question, do you have an obligation to call Dr. Bones after the hearing to discuss this? And for the same reasons, no. You called him as an expert. He testified that he read a bunch of studies and he rendered a certain opinion and conclusion based on that. And you're an attorney that's done a bit of medical research on your own. You have a right to rely on his or her learned opinion. Now, if you talk to Dr. Bones, and he admits that there are studies out there that question the prevention of bone density loss through standing, do you have an obligation to make a disclosure to the ALJ about this? I see Keith shaking his head no. Diana?
I think only if he testified that there are no contrary studies.
If he's
Right.
lied, if he's using the studies that he cites to support his opinion,
Yeah.
that's fine, as long
Yeah.
as he doesn't affirmatively.
And,
Say there are no other
Right,
opinions.
exactly.
Studies.
and again, at the risk of being redundant upon redundant, look at Rule 3.3. Is there a false statement here? No. Now, we could probably change the facts and at some point have him admitting that he did shoddy research and that he's since learned the error of his ways and that he thinks the better research supports this other notion. Then we have a different case. Helen?
I'm thinking, in this day and age, I'm looking at these rules, most medical evidence, I'm thinking is probably not fact, because you can go to three or four different doctors and get 3 or 4 different opinions as to how to treat something. Even one doctor might say you could never work, or another doctor might say, oh, I think work would be good for you. And, you know, just, I'm thinking more that, wouldn't the rules be more like if there was a criminal case and a client said to his attorney, you know, I was over at, you know, Park Street last night at 9 a.m. and then later he says, I was there at 11 a.m. That you're dealing with specific objective facts. But whenever you're dealing with medical stuff, it's not really facts, so can you get out of it that way by, you know, never?
Yeah, always start with, are we dealing with a
What's the
false statement
statement?
of fact? Are we dealing with evidence the lawyer knows to be false? Okay? And if we don't have that, we're not bound to do anything, I would say. But I think your concern is addressed by the next 2 parts of the hypothetical. So
Okay.
we'll let you deal with number D.
Keith, did you get a question?
Well, I think you can be over broad in your statement because it's medical, it doesn't deal with facts. Obviously, a client can lie about the results of a clinical test.
Oh, that's,
And that would be an example. So, but I agree with you generally, you know, there's an awful lot of opinion in medical stuff.
Okay, we're going to do code 3, which is ethics 2014. Ethics 2014. As we're going into the final stretch here. Part D. Immediately before the hearing, Sam tells you that if he wins the fair hearing, he plans to sell the standing wheelchair. then he can buy a wheelchair without the standing feature, and with what's left over, he can buy a home entertainment system because he's really wanted one. Sam indicates that if asked about his intentions during the fair hearing, he will say he intends to use the standing feature of the wheelchair many times throughout the day. What is your obligation?
Well, I was okay until the last sentence. That's troublesome.
Does anybody think that you can just be quiet, let him go ahead and testify, and wait for a decision?
He might change his mind, he might like the standing wheelchair and not do it. You know, that's just, he's saying he's intending to, but that's not
You
saying
know,
that it's really
I think that's a very good point, Amy. And one of the things that Diana and I talked about is,
In fact, that was one of our next, you know, once we got an answer to this, we were going to raise that.
So you think because it's in the future, it's not yet a fact?
Right, it's not a fact.
What?
Can you just withdraw?
I mean, I was concerned that if
right
you,
before the hearing, you've been working on this standing wheelchair case, spending all this time, and your client says, "Oh, I don't really need it anyway."
that's actually a good point. Is there a false statement of fact in the record?
no. But I think there's something else that comes into play here that I'm concerned about, and that's Medicaid fraud. I think your client has basically, I mean, what if you got food stamps? You get food stamps, you go out and you sell them on the corner. I mean, don't they prosecute people for that?
They prosecute you once you sell the food stamps. They don't prosecute you for saying, I'm thinking I'm gonna sell these food stamps.
No, they don't, but attorneys can't help their client commit fraud. So if your client's saying, I'm gonna commit fraud because I'm going to get the wheelchair and I'm gonna sell it and I'm gonna use the money for other things, are you helping your client commit Medicaid fraud by allowing them to testify? Under this, I mean, we'll get into, you know, Amy's point in a minute, but without any further information, you haven't had any further discussion with them, can you let that go? I think there's a fraud problem.
Well, if you put in
I mean, maybe I don't know fraud, but
if you put in a truthful food stamp application with your client, and they said, I'm gonna sell food stamps, but all you're doing is putting in a truthful food stamp application.
Yeah, but the rule says, if you go to 1.6 again, it says you may reveal information to prevent the client from committing a crime. Because I'm looking at it and I'm thinking, if this is really, you know, it does look like fraudulent, like he could be prosecuted for this. But if it says may, then I guess that rule 1.6 still says may, the one that we talked about before.
Yeah.
I don't think that there's a problem until after he testifies. He's only saying that he's going to do this. So he hasn't lied yet. He's saying that he might lie. I think a problem potentially comes once he gets on the stand and he says, I'm going to use the standing feature of the wheelchair many times during the day, then he's lied, which I think makes it different from the food stamp case where they're not lying about their income.
But then you're in the hallway and you say, well, now you said that, and he says, I've been thinking, I think that standard's gonna work out really well for me. So, I mean, because of the intent, I mean, I think that's a
yeah, and we thought that if you had the discussion with your client and just, I saw the error of my ways, I'm not going to sell it. After all, I think you can believe your client and take them at face value, even if you see it a for sale sign 2 months later.
Diana, we got
know.
another
He changed
question.
his mind again.
I was just going to say that you're under an obligation to then talk to your client and say, I cannot support you in perjuring yourself on
Right.
the stand. And you should know, should you do that, I'm under an obligation to correct the record.
As a very practical matter, I think if this came up in the office, we'd probably start by talking to Sam to say, if this is really what you intend to do, I don't think we can ethically go forward with representing you.
Or waste our resources.
Right.
I mean, that's the other issue,
Right.
is that there's resources, program resources I could be spending on other people. I'm not going to spend it on getting you a $37,000 standing wheelchair.
But you're right, the issues come up in the waiting room.
Right.
The Medicaid waiting room, not our waiting room.
Yeah. Yeah.
So then the conversation has to happen. Yeah.
Right.
I mean, if your client knows you're gonna rat them out, then they're probably not gonna lie.
And it's probably not too late for them to fire you and you to just ethically step
Right.
away.
Okay, one more.
Okay, number E. Gets more and more fun. At the hearing, Sam testified that his caretaker has dropped him several times, causing him injury while trying to transfer him into a stander, and that is why the separate stander will not work for him. And by the way, this has actually happened.
Yeah, it's compelling testimony.
It's very
it can
compelling
be a game
testimony.
changer.
However, immediately after the hearing, Sam confides in you that he lied, and the caretaker never dropped him. He really wants the standing wheelchair because he likes to hang out at the neighborhood bar, and the standing wheelchair will let him stand at the bar with his friends. He'll essentially be able to belly up to the bar. What's your obligation? Do you have a false statement of fact?
Yes. Yeah.
Okay,
And it's immaterial.
and it's material.
Central litigation.
Yeah.
You've got to correct it. Is there any way to save this? I mean, the one of the rules I read, or the comments, says you should start first with remonstrating, not a word I usually use.
Whatever that means.
But you should sit down with Sam and say, look, it's okay to use your standing wheelchair at the bar. There's nothing wrong with that. But you can't justify it for that reason. Are you going to use it to engage in your standing therapy program? And what if he says yes? Is he just taking the hint and telling you what you want to hear?
Still hasn't corrected the
It's
No,
hard to
problem
lie.
though.
the problem is the lie of
The
the
problem is the lie. Is it still, if he says, you know what, I've seen the error of my ways, that is not my intent. I intend to use it for therapy. Is that enough?
Dropping
The
is
dropping.
a lie.
The dropping.
It's very material to the
Yeah.
case.
Okay.
Yeah.
Yep. Yep. No. What if he doesn't tell you until after you receive a favorable fair hearing decision? In New York,
Well, wait, what do you do though? To correct, do you have to write a letter to correct the record? That's an uncomfortable position.
yeah,
What do you
it's a
do?
very uncomfortable position.
Because you might have just you probably just killed his credibility at the
If
hearing.
if you look at the literal language of 3.3 in the comments, you have to correct the record.
But I think you can do it in such a way, I mean, yes, you're gonna destroy his credibility, but you don't come out and say, I'd like to point out that my client lied on the stand. You would, my client realizes that he testified that he dropped. What he meant was that he's almost been dropped, or that he has a fear of being dropped, or,
Yeah, but
I don't know what else you
then
do.
you're lying. Then you're lying.
And you're like, I don't think you can do that, Diane.
although that might be true.
You have to just say, not
Withdraw
this,
his
this.
testimony. Couldn't
Yeah.
you just not explain, but just say we'd like to withdraw his testimony?
As
Oh,
to the
yeah.
dropping.
As to the dropping incidents.
Arguably, if you want to try to make 4503 consistent with 3.3, 4503 would say that you can't disclose the conversation with your client, but 3.3 says you have to correct the false statement. So maybe what Diana says, you say, I'd like that particular part stricken from the record. By the way, while compelling, I think you could win the case without that.
The whole case.
Yeah.
Yeah, if he had talked to you first, you probably would have.
Right.
Because you would have been able
That's the
to.
big concern, that now you're bringing up the fact that
Right.
that he
Yeah,
lied
the problem
over
is
the
it
fact.
destroys his credibility
Yeah,
in other
right,
issues.
yeah.
That's-
Let's add
But
another
these are
twist.
very therapist driven.
Let's
So it
add
doesn't
another
destroy the
twist.
therapist's testimony,
Okay.
hopefully.
Let's add another twist, and I'm going to remind people that they're going to need to sign out when they leave here today. What if Sam does not tell you this until after you receive a favorable fair hearing decision? And I'm purposely not telling you exactly when. In New York, you have 4 months to appeal a fair hearing decision as his attorney. But state regulations are silent as to whether the Medicaid agency can appeal, and I would submit that they can't. But the regulations are silent. Now what's your obligation?
Not
think-
representing them any longer, right?
Well, I'm not going to be able to quickly lay my hands on it, but Diana went through something that said if it's not too late to correct the problem, or if the time for appealing has not yet run. So, let's assume it's the day that Diana and her client receive the hearing decision. Sam calls up and he goes, "Oh, this is great. By the way," what would you do?
I
Eileen?
talked to my supervisor.
I would talk to my supervisor, but in the real world, if it was that Sam was acquitted or that someone else was on death row and Sam told me that he really did the murder or that he was really with his lousy ex-girlfriend when she was supposed to be committing the crime, I think other things come into effect. When you're sitting on something and something bad is going to happen to another person, and I had an example in the family law context, that if we had time, which we probably don't, what I would honestly do in that situation, maybe because of my age or other things, I would say, I am sorry, we have a bad connection. Why don't you call me back later?
So this
because
is-
there's a limit, you're not hurting anybody.
This is Eileen. I'm sorry. I can't hear you.
That's what I would do. Honestly, that's what I would do. And that's what most people would do. And a law office that does what we're learning we have to do wouldn't be in business very long. And I'd have the hypothetical I give is somebody is in a custody trial and they tell you, I'm grandma, once I get custody, I'm going to really give the child back to my son, the child molester, and he's going to go over the Mexican border. Then you have issues where there's another human being who's in real danger. When it's whether the government gives this poor handicapped guy a better wheelchair or not, as someone outside that field of law, more power to them, but don't show this tape to
Yeah,
anybody.
let me. Very,
Right on the internet. You can quote it.
Unfortunately, people can
You
watch
won't
it
put me in
forever.
that area.
It's gonna be on
I'm going to react to that, Eileen. Well, go ahead, Keith.
Let me just straight something. Does it matter what the basis for the decision was?
I think it does.
I think that's the point I was going to make. What if you read the decision and it never recites
Material.
that evidence
I think that's
and does a very articulate job of talking about the benefits of standing and why the standing wheelchair is better because the person can do it throughout the day, and there's no mention of without a third party to help them transfer. That may carry it. I'm going to, in the interest of stopping the session officially, maybe bring it to closure right now, and I assume there's no further codes that we have to give. Just want to thank everybody, but particularly thank VLP for sponsoring this to enable everybody to get CLE credit. And we'll have to see how the tape comes out. But let's call it at an end. But Diana and I can hang around for a few minutes if you want to discuss this.